Good morning. There's quite a number of us joining, so I'm going to wait a few moments to make sure everyone can get fully connected here. All right, good morning. I'm going to go ahead and get started with some of my opening statements, as I'll call them. That still will give some folks time to join us in the virtual room. Once again, good morning. It's August 13th, 2024, and I'm Nicole Kinsey, the presiding hearing officer for the Administrative Hearings Office of the State Water Resources Control Board. This is a pre-hearing conference on the pending petitions for change of water right permits 16478, 16479, 16481, and 16482 of the Department of Water Resources for the proposed Delta Conveyance project. This pre-hearing conference is being conducted by Zoom web conference and is also being broadcast live on the AHO YouTube channel. So if you've joined us in the Zoom virtual room, but you're not planning to participate today, if you would please move over to the AHO channel, YouTube channel, I'm sorry. That would be quite helpful to keep the room a little smaller. Both the audio and video are being recorded, and we will post files of this recording along with the Zoom-generated transcript to the administrative record that is available on the board's FTP site. The YouTube recording will also be available on the AHO YouTube webpage. And if at any time you are experiencing technical difficulties trying to communicate with us, please send an email either to the DCP inbox, or you can send an email to the AHO inbox at admin@waterboards.ca.gov. AHO staff are monitoring that email inbox. We also, I believe, have a court reporter in the room. Maybe I'll look to my team. Can you confirm for me that that's correct, that we have our court reporter online this morning?
Good morning, Ms. Quincy. This is Marlon Nelson. Yes, I'm here with you today.
You are here. Oh, thank you. And that's our court reporter.
Thank you.
Thank you so much for joining us. I just wanted to confirm. I realized I didn't confirm with my team. We had a plan. So we also will have the court reporter's transcript available as soon as that is available as well for all of you on the AHO, on the DCP FTP site. Assisting me today are several staff of the Administrative Hearings Office, as well as the Division of Water Rights. And if at any time I am experiencing technical difficulties during this conference and I'm not able to rejoin the Zoom conference right away, one of the AHO staff will call a short recess until I'm able to rejoin. At this point, I'd like to move to appearances. There are quite a number of us, so we'll do this step by step. I'm going to go through this by identifying each of you who filed NOIs with respect to your intent to be here today. I appreciate those that helped me put together this list. If you are representing that party whom I call or representing your own interests, please go ahead, unmute your microphone and state your name. We will also try to update as necessary anyone's heading on the Zoom naming system here to make sure we have all of your names. So I will start with the California Department of Water Resources.
AWR. I'm joined here today with my colleagues Ken Bogdan, Colin Chandler, and our outside counsel, Steph Morris. We're speaking through a common conference phone, so if you notice that our audio isn't on, we're all in the same room.
I see that, and I think I'm going to ask my team, maybe you can give, instead of the phone number, can we change it to Department of Water Resources? And then we'll know the conference. There we go. We have it. That's the conference line. Thank you and good morning. State water contractors.
Good morning, Miles Krieger for the State Water Contractors.
U.S. Bureau of Reclamation.
Hello, this is Amy Oftenberg with the Bureau of Reclamation. I'm also here with Kate Laubach from the Department of Justice.
Good morning.
Thank you. Good morning. Upper Merced River Watershed Council. Westlands Water District.
Yes, good morning. This is Elizabeth Esposito for Westlands Water District.
Thank you. Good morning. South Delta Water Agency, Central Delta Water Agency, Heritage Land Company, and Rudy Moosen Investments LP.
Good morning. This is Dean Reese for those protestants.
Thank you. Good morning.
Good morning.
Byron Bethany Irrigation District.
Good morning. Ellen Moskal for Byron Bethany Irrigation District.
Thank you. Good morning. East Bay Municipal Utility District.
Good morning, John Salmon for East Bay Municipal Utility District.
Thank you. Good morning. El Dorado Irrigation District. North Delta Water Agency.
Good morning, Ms. Kinsey. Kevin O'Brien of Downey Brand for North Delta Water Agency.
Thank you. Good morning. Placer County Water Agency.
Good morning, Elise Nelson for Placer County Water Agency.
Thank you. Good morning. Central Delta Water Agency.
Good morning, this is Brett Baker on behalf of Central Delta Water Agency.
Thank you. Good morning. And it looks like I got smart and grouped these together, so let me know if I'm right. Sacramento County, Sacramento Area Sewer District, Sacramento County Water Agency, City of Stockton, Nagley Burke Irrigation District, and Pescadero Reclamation District number 2058.
Yes, good morning. Kelly Tabor from Somac Simmons and Dunn on behalf of those parties. And also with me this morning is Luenda Lacey.
Thank you. Good morning. San Joaquin County, Solano County, Contra Costa County Water Agency, and local agencies of the North Delta.
Good morning, Tom Keeling on behalf of the entities you just named.
Thank you. Good morning. Steamboat Resort. Buena Vista Rancheria of Miwok Indians, Shingle Springs Band of Miwok Indians, Winnemem Wintu Tribe, Little Manila Rising, and Restore the Delta.
Good morning, this is Tara Bear representing those parties, and three of them will also be speaking up as well if they'd like to introduce themselves.
You're welcome to introduce yourselves if you're here on the line.
Good morning. Crystal Moreno with the Shingle Springs Band of Miwok Indians.
Gary Mulcahy, Government Liaison for the Winnemem Wintu Tribe.
Good morning, Barbara Berrigan, Puria, Restore the Delta.
Thank you, and good morning to all of you. And Ms. Bear, I don't mean to, I am, I'm going to call you out. Are you a student joining us today?
I am. I'm a student attorney from Yale Law School.
Wonderful. I'm so happy you're here.
And thank you.
And so I don't know, for those who are listening, I would love to have more law students join us for these proceedings, particularly where we have unrepresented parties. We have a need. So please spread the word. But thank you for joining us.
And this is Stephanie Safty. I'm a supervising attorney with Yale Law School.
Wonderful. Thank you. And thank you for bringing your students in. California Indian Environmental Alliance. California Sport Fishing Protection Alliance.
Morning, Chris Schutz with the California Sport Fishing Protection Alliance. My colleague Sara Vardaro is on YouTube.
Thank you. Good morning, Mr. Schutz. California Water Impact Network.
Good morning, Roger Moore here for California Water Impact Network.
Thank you. Good morning. Friends of the River.
Yeah. Good morning. It's Gary Bobker for Friends of the River. Jan Dorman of Friends of the River is also on the call.
Thank you. Good morning. Save California Salmon.
Good morning. This is Bob Wright, and I'm representing them.
Thank you. Good morning. I have Sierra Club California et al., which includes Center for Biological Diversity, Friends of the River, Planning and Conservation League, Save California Salmon, and North Coast Rivers Alliance.
Good morning. Again, this is Bob Wright. I'm representing those parties.
Thank you. I see I have them connected. They're right next to each other. Okay. Thank you very much. Good morning.
And this is John Bussey, also on for Center for Biological Diversity and some of the Sierra Club parties.
Thank you. Good morning. Pacific Coast Federation of Fishermen's Association and the Institute for Fisheries Resources.
Glenn Spain, appearing as attorney for both of those.
Thank you. Good morning. Golden State Salmon Association.
Good morning. This is Scott Artis with Golden State Salmon Association.
Good morning. Save the California Delta Alliance and Hood Community Council. San Francisco Baykeeper.
Good morning, Eric Busher for San Francisco Baykeeper.
Thank you. Good morning. And Deirdre Desjardins.
Hi, this is Sherry from the California Indian Environmental Alliance. I was having a hard time with the mute feature.
Wonderful. Good morning, Ms. Norris, and thank you. I have you checked off the list. Thank you. I've now been through what I had for NOIs. Is there anyone who is also on the call who plans to participate who has not had a chance to introduce themselves?
This is William L.
Barbara
Martin.
Vlamis with Aqua Alliance is here.
I'm sorry, can you, with Aqua Alliance, will you please state your name one more time?
Barbara Vlamis.
Thank you. Good morning.
This is William L. Martin with Sierra Club, California, and I don't know yet whether I'm going to speak.
Thank you. Good morning.
This is David Fries. I'm representing San Joaquin Audubon Society.
Thank you. Is there anyone else who has not had a chance to identify themselves? All right, I'll go ahead and jump into the substance here. As you know, the AHO issued a notice of pre-hearing conference for this pre-hearing conference on June 19th, which was somewhat unconventional because it was before the time the hearing notice came out. The purpose of that was to put this on calendar right away so that we could have this conversation. We did issue that notice of public hearing on July 31st, which hopefully all of you have seen and had a chance to take a look at. The pre-hearing conference notice identified a few topics for a conference today. I do want to narrow that because I think we really do want to deal with the most important issue, which is the schedule. That's the elephant in the room, and that's what we all want to talk about. I think some of the other more minor issues that I identified about a site visit and a court reporter we can deal with later. So I would like to focus strictly on the schedule that was identified in the July 31st hearing notice and grapple with that, and then we can come back to those other issues as we have firmed down our schedule for this proceeding. And I do plan to have at least, I think you saw it in the schedule, at least 2 more pre-hearing conferences. I think that's appropriate. I think we'll need the time to talk about how to conduct this hearing in an orderly way. On that note, I'd like to take a brief opportunity to talk about the general process for this proceeding. It's our first time meeting together today. I appreciate that you all are here. We're going to be spending a lot of time together over the next years, I'm sorry to say. And so we might as well start off carefully. We're well in advance in the beginning of the hearing, even with what I would call a fairly aggressive schedule. But I did want to describe my role and the role of my office. I will be presiding as the hearing officer for this proceeding, and that's in accordance with the assignment made by the board's executive director. Our intent is to hold this hearing primarily by Zoom. Board members may appear on the Zoom platform to participate as well. As you can imagine, they are keenly interested in this proceeding, and you will be seeing them. If there is going to be a quorum, we are going to schedule, in accordance with the law, we will schedule hybrid days where there will be a physical space, a physical meeting space. You're welcome to join us in person on those days, or you may continue to join us by Zoom. So we will maintain the flexibility. There will always be a Zoom option. But on some days we may schedule a hybrid hearing, and we will I'll try to notify you as well as I can in advance. So if you want to take advantage of that opportunity to be in person, you can make appropriate plans to do so. We can talk about all those logistics as we get closer. I see my role in this process and the role of the larger hearing team as having the purpose of running a hearing process that will develop an evidentiary record that the board will rely on to make its decision. The board will be making the final decision on DWR's petitions. And my role is to bring this hearing forward in an orderly manner and bring to the board a recommended decision based on the evidence that's developed through this process. Part of the assignment to me was a direction from the board that this hearing should proceed as immediately as possible. But of course, we also need to do that in a manner that's fair and reasonable. So we're balancing these various factors. My role is to guide this process and set a schedule that is fair, that is sensible, that will develop a thorough and robust record so that the board can make an informed and the best decision possible. And also moving this proceeding forward as one of the board's highest priorities at the moment. I very carefully considered the objections that I received from some of you about holding this pre-hearing conference so early in the proceeding. As I acknowledged, issuing a pre-hearing conference notice before the hearing notice is not normally how we do things, although we've done this in other matters where we weren't sure whether we were going to hearing. But it was really important to me, my ultimate conclusion for running this pre-hearing conference early in the process was that I need to hear from you and the board needs to hear from you about these scheduling considerations, because I know there are a lot of concerns. So that's why we're here today. That's why we're here so early and gathering early. After the evidentiary portion of this hearing is complete, which is a good ways down the road, the AHO and the Division of Water Rights staff will prepare a written recommended decision. As I mentioned, all of you as parties will have an opportunity to comment on that draft. And then the board will consider at a regularly scheduled board meeting whether to adopt that recommended decision, whether to make changes to that decision, or whether to send the matter back to the AHO for additional proceedings, and that could even include additional evidentiary proceedings. So again, I want to be clear that the board will be making the final decision in this proceeding, but I am here to manage the process and make procedural decisions. Again, today I want to focus on the schedule. Any changes that should be made to the schedule, and most importantly, what I want to hear from you are the reasons you have for suggesting or bringing forward these proposed changes to the schedule. As an example, in the Sites Reservoir proceeding, we gathered for a pre-hearing conference, and I became aware through that process about the status of the incidental take permit, which is an important piece, evidentiary piece. And that affected our scheduling considerations. So that may be those types of conversations I hope we can have today, so that I can hear from you about the evidentiary gaps that there may be in proceeding in accordance with the schedule that we've laid out in the hearing notice. And then, of course, anything else that you think we should consider when thinking about whether there are appropriate changes. I did receive I received their prior letters from several parties with respect to this pre-hearing conference and moving this pre-hearing conference. I also received pre-hearing conference statements from, I believe, 5 of you or 5 groupings of parties. I've read all of them carefully and I appreciate those, and I will go back to them as well. All of these documents are posted on the FTP site for the Delta Conveyance project. And I just as a note, for this proceeding, I encourage all of you throughout the proceeding to check that FTP folder to make sure your filings are there. If your filing is not there, that means something went wrong. We either misfiled it or we didn't receive it. So please do check. And if you think something should be there and you either can't find it or it's not there, send us an email and just ask about status, because things sometimes we're not perfect. And that's the best way to make sure that we receive something. And that is the official administrative record, that what you see in that FTP folder. I'll take a brief pause. Here's what I see for the day. I thought I had a few specific questions for the petitioner, DWR, and then I wanted to just move around the room. I was planning to just go in the order in which I called for appearances earlier, so you can get a sense. Unless you'd rather go in a different order, you can let me know. And hear from all of you, and then I wanted to go back to the petitioners. I assume you would want an opportunity to respond, and we'll just see how the conversation develops from there. But before I jump into that, are there any other overarching questions or issues that I should address before we jump into this conversation about schedule? And you can either raise your actual hand or your virtual hand. It's up to you. All right. I will look to DWR in your conference room. I have 3 pages of Zoom, so I can't, and you're not on, there's no video anyway, so I won't look for you. But I just briefly thought it would be helpful to touch on, I think some of the other parties raised some questions about specific, the timing of specific documents, and to the extent you're able to shed a little more light on the status of those, I think that would be helpful. I know the incidental take permit for the project would be one question, if you have an idea about the timing for that. And then there's also the, excuse me, I'm pulling up my notes. It'd be better if I can look at my notes. Well, let's start there. Let's start with the incidental take permit. And then my next question will be about, there was a question about an operations plan. And if you have any additional information about that, and we'll go from there. So I'll hand things over to DWR.
Thank you, Hearing Officer Kinsey. Yes, with regard to the ITP, DWR filed its application for the incidental take permit in April of 2024. During that time, we also published a schedule on our website, and we anticipate that we are on schedule and that the permit will be issued in October.
Great. They're busy over there.
We're trying to keep going.
Okay. Okay, so that's helpful. And then there was some questions, I think, from the other parties about an operations plan. I don't know the details of, I mean, obviously this isn't a defined term. So if you have any comments, or if there is, if you have any comments on what that might be, and if it's something that's forthcoming, and just as a background caveat, and you probably would recognize this, I haven't been on the website, I'm not out perusing anything, so I'm coming to this with very little knowledge on the background in terms of scheduling, with the intent that I'm avoiding any ex parte information. So assume I'm a blank slate and fill me in, please.
Absolutely. Thank you. Yes, we've also heard talk about an operations plan and the need to have one. So we have been working on a draft of that, and we anticipate that we'll be releasing an operations plan by the end of August. And essentially that is not going to provide any new information. That's only information that's already been made available to the public and to the protestants here that was contained in our final EIR and also in our ITP application. We do recognize, though, that with the issuance of the permit that the operations plan may need to be updated. So we will do that timely after the issuance in October.
Great, thank you. I appreciate this. So I'm going to keep on stepping through. Another question that came up in the pre-hearing conference statements was about the final environmental impact statement. And so my question is 2 things. 1, do you have an estimate on the timeline? And 2, is there any reason I should anticipate that there's something different in the EIS than was in the EIR?
I'm going to look to my colleague, Ken Bogdan.
Hi. The Army Corps of Engineers, of course, released a draft EIS focusing mainly on the construction aspects of the Delta Conveyance project. They are estimating that they will issue the final EIS by the end of this year. And there is not expected to be any differences between the project that's presented in the Corps' EIS that was presented in DWR's EIR.
Great, thank you. This is quite helpful, so I'm going to keep on moving. ESA consultation, that was another question that came up. What is the estimated timeline for that?
So the Army Corps of Engineers submitted biological assessments to both NIMS and Fish and Wildlife Service early this year, and it is expected that those the biological opinions will be completed. Working with Fish and Wildlife Service and NIMS and trying to coordinate their schedule as they're also working on some other rather large efforts. But that's expected either late this year or early next year in terms of the construction, and operations will be handled also as part of the larger state water project Section 7 process programmatically. And of course, for the operations in the Corps' EIS, the biological assessments that have been submitted, all of that is consistent with what has already been presented in the EIR and consistent with the ITP application.
Okay, let me unpack that a little bit, and part of this is my own learning curve here. Thank you, first of all. So the construction portion is coming sooner, and then the operations portion will be addressed programmatically only? Is that how that works?
Yes. How the services define programmatic is, of course, their perspective. We feel we've given them, from an operations analysis standpoint, the same information as we have in the ITP application, which is project specific, but they're calling it programmatic, and that's done as part of the larger effort related to the State Water Project. Timing-wise, I'm not so sure the construction-related opinions will come before the programmatic analysis. We don't have any control over the federal agencies and their schedules, so we're beholden to them. But again, the focus is on the issues that have been framed and presented in the EIR in terms of impacts to listed species and, as I've already mentioned, operational components and those effects to.
Great, thank you. And then my last question is about the consistency determination with the Delta plan. That is something that's intended to happen after, is it after or concurrently with this water rights process?
The Delta Stewardship Council has expressed their interest in having the water board's hearing go first in order to inform the Delta plan policy related to water quality issues. Timing-wise, we expect that to happen depending on a number of different factors in terms of the schedule for this hearing and in relation to the Stewardship Council's own timeline.
Great. Thank you. I appreciate all that, and I appreciate the answering my rapid fire, but I thought we'd cut to the point on some of these, and that may help us work through. Are there any other comments you'd like to make before? As I said, what I'd like to do is go around the room and then come back to all of you with DWR. But is there anything else you would like to comment on now?
Yeah, I just wanted to say that DWR really appreciates your statements about keeping the pre-hearing conference date. We think these conferences are really important to streamlining and creating efficiency in the hearing process. So we appreciated the openness of the timeline and sticking with it. This is a very important project for DWR and how it serves our disadvantaged communities and preserves our really scarce resources for the state. So we appreciate the timeliness of the board's understanding that we want the hearing to proceed as immediately as possible. Thank you.
Thank you. With that, as promised, and I'll look to my team who's doing a fine job of pinning the right people up here, so to speak. I think, as I mentioned, I'm going to proceed in the order I called for appearances, just so we can all be aware. So I will turn to state water contractors. Do you have any comments on the schedule?
Yeah, thank you, Hearing Officer Kenzie. The state water contractors are fully supportive of the department's position with respect to the schedule. And so I don't have anything specific to add other than we do see a risk presented in the various written statements filed, in which you'll hear today, of an inordinate delay if some of those are entertained. So I wanted to express that concern, but also we're fully supportive of how the department views the schedule.
Thank you. And the Bureau of Reclamation, do you have comments on the schedule?
Hello, thank you for the opportunity to comment on the schedule. We don't have any comment on the current schedule.
Thank you. Appreciate it. Westlands Water District.
Yes, no comments on the schedule from Westlands Water District. Thank you.
Thank you. South Delta Water Agency et al.
Yes, the schedule from our perspective is premature. It's too condensed. We join in the other some of the statements submitted that points that out. We just simply, the idea that we would have resources to participate in, fully participate in the Sites Reservoir, which goes Sites Reservoir project and aspect and petition and hearing, which goes into mid-October, and then have case in chief testimony for this submitted by December 4th. Just is not realistic and is highly prejudicial. And we urge you to seriously reconsider this.
Thank you. Byron Bethany Irrigation District.
UPAD joins in any comments that are presented by Kelly Tabor. I think she's going after me on the list.
I see this, yes.
Thanks.
I probably could, well, I have, you're separate but related. Thank you.
Exactly.
EB Mud.
East Bay Mud has no comments on the schedule.
Thank you. North Delta Water Agency.
Yes, Ms. Kinsey, I just wanted to raise a question regarding the operations plan, which apparently is going to be released here sometime in the next month or two. That is going to be a very important document in this proceeding because it's going to tell us more than the EIR told us about how this project will actually be operated, and will be very important in the parties being able to develop their evidence for the hearing. I think the indication was that operations plan would be released by the end of August. But if that date slips and we get further into the fall, it's going to create some real potential hardships, I think, in terms of parties being able to have their experts review and analyze that document. So I just want to note that at this point, and we may have to come back to that if there is slippage in the release of the operations plan.
Thank you. That's helpful. Did you have other comments, Mr. O'Brien?
No, I don't. Thank you.
Thank you. I appreciate it. Maybe I can, on that, just for clarification, I'll turn back to DWR. I think what I heard, and I think these things are all correct. What I heard from you is the operations plan is going to reflect operations that will not include information in addition or new as compared to the EIR. However, what I also heard from Mr. O'Brien is anticipation that the operations plan will be more specific, and both of these things can be true at the same time. So I wanted to turn to DWR for confirmation that the operations plan, although it will not address anything outside of the EIR, is the intent that this plan will be more specific than the operations discussed currently in the final EIR?
I don't believe so. We're really taking things directly from the final EIR and the ITP application, which are both public documents. So it may be clarifying. I don't know if necessarily that would mean more specific, but the information should not be changing, nor the basis upon which it is created. Sorry, my Zoom is telling me to turn on my audio. It does provide more information specifically to operations, as the name suggests, for the plan, though, so the emphasis will be on the operation of the project. and how it will be implemented.
All right. I think I don't want to take too much time opining about what's in a document that only you have seen. So we'll know what it says when it comes out, but thank you. We can come back to that. Others may have questions there too, but thank you for answering that question.
Yeah, and Officer Kinsey, we are going to confirm this will be out by the end of August. There will not be a slip in the schedule.
The end of August is very soon, so it's coming very soon. Okay. With that, I will keep moving forward. Placer County Water Agency, do you have any comments?
We don't have any comments on the schedule at this time.
Thank you. Central Delta Water Agency. Do I have Mr. Baker? Do you have any comments?
Apologies, I was still on mute. Should know by now. Officer Kinsey, we share some of the same concerns about the scheduling and the timing of this hearing, and I could expound on those more if you'd like, if it pleases you at this time. But I think we'll get into some of that stuff later on. But yes, we too have issues with the timing of the schedule, and
I think now is now is the time. So
all right, I'll boil it down to, I think I can do it in about 2 or 3 minutes. All right. Okay. So you said you're a blank slate. So I just wanted to give you a little bit of historical context. Central Delta Water Agency submits copious written comments and various attachments there too. We apologize for the quality. Some of those attachments are hard to read. So I just want to try and hit some of the bullet points here. In the current operations, I guess in a perfect world, this facility, this proposed project could be operated in a way that was beneficial to the ecosystem. But I think if you look just at the history of mankind and the history of California, further, the construction of an upstream diversion facility has never benefited the water quality or water users. Subject to water.
Let me frame this a little bit, Mr. Baker. I may have been unclear. We're talking about the schedule today. I mean, it's a pre-hearing conference. We're talking
right.
So as long as you're getting to the schedule, I'll
get there. It'd take me 2 minutes.
We start with the history of mankind. I want to make sure we get to the
sure. Okay. Well, let's talk about the history of state water projects. So we're about 5.5 million acre feet of water short of what we were going to build for storage on the North Coast to meet in-basin needs by the year 2000. And I think that if we look at some of the laws that were put on the books at the time. I'll even read a few of them off to you if you want to get familiar with them, because we're going to bring them up later. 10505.5, 11460, 12200. Those laws were put in place. And if we look at the operations of the project historically, and if we look at the operations of the project currently, I believe the rules of the road are CVPIA and the BIOPS. And since D1641's come into place, every time we get into a critical or dry year, the board issues a TUCP, continues to transfer water, changes and modifies the place of use for the State and Central Valley project. Okay, so and we do not operate this project to meet the historical drought of record, which is 1929 through 34. So that is, I think, an essential element of what we're talking about. And currently, we're standing here today, going to reshuffle the deck on some of this stuff or give us a major opportunity to, while we have a long-term operations plan that is outstanding, severely insufficient, in my opinion. My completely biased opinion. We're going to update water quality the water quality control plan in the Delta here shortly, supposedly. And we're going to talk about the sites project. This all takes a lot of air out of the room for everybody who's involved in all of these discussions. And fortunately or unfortunately for us, we have to be involved in all of these discussions because they all affect our water users in the Delta, along with the state project. And so I just want to put that in context. And the last thing I'll say is that the board has been very dismissive of their public trust duties. Okay. So I won't do you the disservice of reading the quote out of the Audubon case right now, But the board has a pattern and practice of approving those TUCPs, transferring water, ignoring water standards. We violate those standards regularly. Only when it gets real bad do we issue a TUCP. And the whole time, our public trust resources like salmon, sturgeon, smelt, steelhead have continued to decline. So we continue to just ignore what is going on with the public trust. And I think that is the biggest crime that's perpetrated while we take public trust dollars. That's one other aspect of the public trust. We're talking about spending public funds to do some of these projects, sites, and this DCP project. So I think the board needs to take a real look at their public trust obligations. And I think that needs to be put front and center of what's going on here in the DCP. So I just wanted to lay that out in the historical context of since the history of mankind. I do not believe that there's ever been an upstream diversion that has benefited the water quality and or the environment downstream of the diversion. And it's possible, it's highly unlikely. That's all I have to say. And we're going to get into all the details about why and how this has happened over the last 70 years in our state.
Thank you, Mr. Baker. I think, can I focus you for a moment on what would you like me to take away today with respect to the schedule?
It's premature.
Okay, thank you.
Small point. Sorry. Had to go there.
Thank you. I will now turn to I'll call you this, if I may, the Sacramento County grouping. I know there are a number of parties, but Ms. Tabor.
Yes, thank you. I'll echo the comments made in our pre-hearing conference statement that it's premature to be scheduling anything other than further status conferences at this point, and the lack of an operations plan and the ITP are key components of that. Our clients have expressed a desire to engage in a meaningful protest resolution discussions, and the operations plan is essential to those. We've been promised that plan for several months. I'm happy to hear today that there is a firm date because we've been asking and gotten no response, crickets to our response. So our position on the schedule would be that we shouldn't even be talking about another pre-hearing conference until we've had a meaningful protest resolution period that starts from the date of the release of the operations plan. I understand the department's representation that it won't have anything different than what was in the EIR or the ITP application. We haven't seen the ITP application, but our clients were unable to find sufficient information in the EIR to address their concerns, which is one of the reasons they're participating as protestants in this proceeding. The EIR wasn't sufficient to explain that. We hope and expect that there will be a lot more information that we can use to engage in a meaningful discussion and resolve or at least narrow the issues for hearing. So having to develop testimony at the same time that we're evaluating an operations plan and attempting to engage in a good faith discussion about means to resolve or narrow protests would be a huge waste of resources. And I would note that many of our clients include disadvantaged communities. And so I understand the department is touting the project is benefiting those groups, but it's a big burden on the residents of the Delta and disadvantaged communities in particular to have to undergo this a very extensive effort involved with participating in the hearing and developing testimony. At the same time, they're trying to understand what the project is based on new information that might be available in the operations plan. So that's our essential position. And we would request that you schedule a further status conference for 6 months after the release of the operations plan, so when the parties can report on progress on protest resolution and begin to discuss a schedule for submittal of testimony. Thank you.
Thank you. Ms. Tabor, I have just a follow-up question for you about negotiations. I am, of course, very interested in supporting any opportunity to resolve resolve protests before this proceeding. Obviously, that's certainly one way to enhance the efficiency of the process. So I guess I'm trying to figure out how to frame this, but my question is, do you think there is, I realize you can't make any commitments at all because these negotiations, it sounds like, are just starting, but do you think there is some possibility that your clients could reach an understanding or some agreement that would at least narrow the issues in their protest through negotiations with DWR?
Well, that is the hope of our clients. And I would say perhaps not all of them, but certainly most of them don't want to spend a lot of money in a hearing. They would like to have their issues addressed and resolved and have certainty. So they've proceeded with and represented that they're very interested in a substantive discussion, but they need more information to have those discussions, and they need the department to be available and responsive to enable those discussions.
Thank you. I appreciate that. Thank you. I will turn next to the San Joaquin County grouping. I believe that's Mr. Keeling.
Good morning, Officer Kenzie. Thank you very much. First, rather than delay this, let me say that we join 100% in Ms. Tabor's comments, as well as in Ms. Tabor's August 9 letter on behalf of the county of San Joaquin and others, or Sacramento rather, and others, as well as in Mr. Roger Moore's August 9 letter on behalf of CWIN. We fully concur in those comments. In addition to the prematurity in the schedule, which has already been alluded to, my colleague OSHA Meserve, whom I should have mentioned in the introduction, by the way, just reminded me that about the fact that our Delta farmers, we represent, among others, local agencies of the North Delta, our Delta farmers, some of whom have protests pending, are still busy with harvest and won't have time until October to begin work on this. In addition to the prematurity inherent in the schedule, which is shocking to me because I spent 3 years between 2016 and 2018 in the prior evidentiary hearing, and I'm acutely aware of how technical and difficult and challenging the 24 or so issues you're likely to have before you really are, and how intricate that evidentiary record will likely be. It is plainly premature. For example, there is no way that a responsible evidentiary record is going to be prepared by the time we submit documents on December 4. That's probably not possible. Certainly not possible to have the kind of evidentiary record that you yourself referred to earlier in this conference that you want to present to the board so they can make a responsible decision on a proposed project of great moment. And finally, I don't want to go back to the beginning of mankind, as Mr. Baker did, but I think the schedule here should be put in perspective. I fought the peripheral canal in 1981 and 82, and we won. That was the isolated conveyance that Governor Brown had. It was defeated in that referendum. It reared its nasty head again in the Bay Delta Conservation Plan, another isolated conveyance proposal. It had been talked about in CalFed, but it became serious in Bay Delta Conservation Plan. And that highly contested project, the result of much litigation, went, as predicted, and properly so, the way of the dodo. Then it reared its head again in Waterfix. And we spent years litigating Waterfix, and it too went the way of the dodo. Now, the same isolated conveyance proposal, in effect, has reared its head again in the Delta Conveyance Project. The Department of Water Resources just lost its validation action. It's now on appeal. The proposed financiers haven't signed on yet. For example, Metropolitan Water hasn't committed to this project. In the CEQA litigation, which is ongoing, DWR is now talking about appealing the injunction And knowing, as I do as an appellate specialist, that's going to be a year or two before they can even get out on the field to do what they consider and have told the judge are preliminary geotechnical studies necessary to get this project going. So what I'm saying is, not only is this schedule premature, it's unnecessarily premature. And with that, I will subside.
Thank you, Mr. Keeling, except I'm going to ask you a follow-up question, which you may tell me you can't be so specific, but premature. I have heard that clearly. When is the right time from your perspective?
Okay, fair question. Certainly, nobody's putting together a responsible, as far as I know, from the petitioners, a responsible evidentiary showing until we know something more about operations. So at a minimum, we need to have a more detailed operations plan. Two, the design on this proposed project is so immature. It's such an early stage that we're going to probably see what we saw in the 2016 to 2018 evidentiary hearing, changes along the way, and they were sometimes substantial. They don't even know what their project is at this point. There will also be water rights, and that was a bugaboo. I remember the hearing officer in 2016 said at the hearing, "Don't worry. We realize that DWR's water rights that are at issue in this hearing are the subject of applications for extension that have never been acted on, even though they were many years old, and the subject of protests that have never been acted on, even though they had been pending for years. Don't worry," we were assured, "this will all be taken care of before the board rules." Well, of course, they never were taken care of. Similarly, we were assured, don't worry, the EIR, the environmental review, will be taken care of. Remember, that hearing started in effect in 2016. The EIR wasn't filed until late 2017. Well, now they filed the EIR. It's in litigation. It may or may not survive litigation. There's already been a preliminary injunction stopping it cold, at least the geotechnical investigations. So I would like to see further development so we know what the project is. We know what the operations are, and we have a better sense of the water rights that are supposedly underlying the whole thing before we get into an evidentiary proceeding as to the proposed change in point of diversion, which will require very technical, hydrological, biological, botanical, terrestrial species evidence about impacts on communities and so on, especially marginalized communities and so on. So historical communities such as Locke. Before we do this, let's find out really what the project is. That's my response to your question.
Thank you, Mr. Keeling. And then I'm going to, and just because you're on the spot, I don't know if I apologize, but you brought it up, so I can ask one more.
I think I'll go silent and dark here.
Which my question now on this, on the petition for extension of time, that is something that we alluded to in the hearing issues because it's there. Is your position that and as I understand right now, and someone can correct me, but as I understand right now, there is no currently pending petition because the ones that were previously filed have now been, maybe they're withdrawn. Anyway, they're essentially moot because the extension would be for in the past. Is your position that if DWR files another petition that should be brought into this hearing, or that this hearing on the Delta Conveyance project shouldn't occur until some decision has been made on DWR's permits for which the deadline for development has expired?
Well, certainly the latter, because if it turns out, as I believe it will, that the water rights necessary for this diversion simply are not there, it doesn't matter that there was a procedural maneuver by which the application and the protests were just suddenly evaporated by fiat, which I understand is what happened. Maybe I'm wrong. My colleague, Ms. Meserve, is not available today. She's actually involved directly in that litigation, and there are perhaps others here who are. I remember that I believe CSPA had a protest, and Central Delta, I believe, had a protest. I don't know, but how do we get through a year-long evidentiary proceeding without understanding what the water rights are? They're certainly going to have to apply for an extension or do something about that. They can't just keep them in cold storage forever. So I don't understand how we can proceed without that. On top of all the other issues I mentioned, and I apologize if I'm less than specific. I wish I were involved in that litigation. I am not.
No, I appreciate. Thank you, Mr. Keeling. And there will be chances. I know Ms. Meserve is not able to be here on this, but we will certainly be talking about this. I will give you, Ms. Carroll, a chance to jump in. We talked about a lot of things, so I will give you a chance to interject, so to speak, and then I will return to the list. Ms. Carroll.
Thank you. I was just going to ask if you wanted us to address some of these issues before we kept going on. So I just want to go back to some statements made by Ms. Tabor. We actually contacted her on behalf of her clients in May and have been in contact with her through the summer, offering to meet with her for settlement. We've actually contacted all of the contestants for this hearing and have reached out to set up meetings. We've had over 60 settlement meetings so far, and we're continuing to have meetings after this pre-hearing conference through the protest resolution deadline. So we are definitely open to resolving any of the claims prior to the evidentiary portion of the hearing. We also wanted to just differentiate this hearing. This is not the California Water Fix project. The operations of the Delta Conveyance project are significantly different, and they're focused on capturing excess flows. So what happened with Water Fix really isn't pertinent here. We've already issued our final EIR. As we've stated, our operations plan is going to be pulling from our final EIR and the ITP. That information has been out since April of 2024 for everyone to review. So we don't believe that that's a sufficient reason for delay of any of the deadlines that we have been proposed so far. With respect to time extension, I did want to address that and let people know that we will be withdrawing the 2009 pending petition, and that will also occur before the end of August.
And that, of course, raises the question, Ms. Carroll, and I don't know if you're prepared to answer it, but will DWR be filing a new petition?
We will eventually be filing a new petition, but we believe that we can file a minor amendment to this petition to address term 6, which is specific to construction, and that the subsequent petition can address the operations timeline.
I'm sorry, I didn't understand that. Are we talking about petition for extension of time under your water right permits?
For construction for DCP here, we need to amend term 6 to extend the deadline from 2000.
I see. I understand. Thank you. Thanks. So it would occur in the proposal, at least what you're thinking today, is that there would be two elements. There would be two petitions?
No, I'm sorry, I misspoke. It's going to be a minor amendment to this petition to amend that deadline to extend from 2000 to the appropriate time frame we need for construction for the intakes and the DCP project. And there'll be a separate time extension petition to address the SWP water rights in general.
I see. So it is two it is two petitions. Okay, thank you.
Yeah.
And that separate time extension petition would be something that, as to your sitting here today, I'm not trying to hold you to it, but that would occur sometime later, is the intent.
That's correct.
Okay, thank you.
Officer Kenzie, may I be allowed a response to that? This is Tom Keeling.
Well, let's, yes, but as long as it's helpful for our scheduling conference, we'll have plenty of time to discuss the merits of.
Not the merits, but
yeah.
but I think Ms. Carroll, who just responded, made my point that this is not ready for prime time. And by the way, that amendment so-called minor amendments going to be the subject of a barrage of protests. It will be a major deal. These are not little footnotes. This is not ready for prime time. That's my comment.
Thank you, Mr. Keeling. And Ms. Carroll, back to you. Do you have anything else?
Yeah, this is not something anyone should have not anticipated. The final EIR and our petition specifically state that construction is necessary. All of the information is already currently available. This is merely an extension of the time from 2000 for construction.
Thank you, Ms. Carroll. Are there any other points for now before you will certainly have you'll have another chance to be in the spotlight, but thank you. Moving down my list, it looks like I turn to Ms. Baer on behalf of your clients. Do you have any comments on the schedule?
Yes, we have a lot of comments, and I'll bring in a couple of my colleagues in a few minutes
Wonderful.
to discuss additional specifics. But the core of it is that Buena Vista Rancheria of Miwok Indians, Shingle Springs Band of Miwok Indians, Winnemem Wintu Tribe, Little Middle Rising, and Restore the Delta are requesting to decelerate the hearing schedule. At the core of the request is, as Ms. Tabor mentioned, the need to respect the 180-day informal resolution period that is mandated by the California Water Code. This is a crucial phase that is intended by law to allow parties to resolve disputes through good faith negotiations before we resort to formal adjudication. The proposed schedule as it stands now undermines this requirement by rushing us into hearings before that period has concluded in mid-November. And as has been stated in the site's reservoir proceedings, the board did respect that full informal resolution period, scheduling the first pre-hearing conference only after that period had ended and the parties' positions had been clarified. Unfortunately, the current schedule right now for the Delta Conveyance Project hearings ignores this precedent. And I think our point is that the prematurity of the schedule right now not only risks compromising the integrity of the negotiations going forward, but it also violates the legislative intent behind the informal resolution process. And that's not merely a procedural issue. It's about maintaining the integrity overall of the process and ensuring that all parties have the opportunity to engage meaningfully in these critical discussions. And to that point, I just want to emphasize the impact that this accelerated schedule has, particularly on tribal nations and other marginalized community stakeholders who are deeply involved in both the Delta Conveyance Project and the site's reservoir proceedings. As Mr. Baker mentioned, the Delta Conveyance Project and site's reservoir projects are very closely interrelated. Many of the parties involved, including tribal nations with profound and enduring relationships to the Bay Delta waters, and nonprofit organizations who support these tribes and affected communities, are already stretched quite thin. These groups face significant challenges in balancing their participation in both proceedings, given their limited resources and the overlapping schedules and deadlines between the two projects. They are right now expected to prepare and present their cases in the site's reservoir hearings, which begin on August 19th, while simultaneously participating in pre-hearing conferences for the Delta Conveyance Project today and into the following weeks. And then just days later, as it stands, they must submit written comments on the hearing issues for this proceeding by September 5th, all the while continuing with the intense schedule of the site's reservoir proceedings. And again, this is not just an issue of time management. This is a matter of fairness and equity, especially since tribal parties are engaged in annual ceremony this month, which you will hear from them about in a couple minutes. The proposed hearing schedule also includes many dates and deadlines that are around the holiday season, which make full participation by the parties even more untenable, and only minor extensions of the schedule are not going to get around that issue. Ultimately, tribal nations and community advocates are being forced right now to navigate two complex and resource-intensive processes at the same time, and that jeopardizes their ability to effectively participate in either of them. And the bottom line for us is that is an unreasonable and at this point fairly easily fixable burden. And my colleagues will speak more to those specific burdens in a couple of minutes. But in the meantime, I would urge the board to remember the 2021 adoption of its racial equity resolution, in which the board acknowledged that its programs were established over a historical structural framework that perpetuated racial inequities and that these inequities persist today. That resolution committed the board to center its work and decision-making on Black, Indigenous, and people of color who are disproportionately represented in California's most vulnerable communities, including the Bay Delta area. So by failing to address the concerns of these communities that have been brought to the board and the hearings office clearly and repeatedly by the parties who are affected the most by the Delta Conveyance project and the associated hearing and pre-hearing schedules, the board is failing to meet the directives set by its own racial equity resolution. And I'll remind you that this is the same board that is currently under investigation by the EPA for its failure to update the Bay Delta water quality standards and for its exclusion of tribes and Black, Asian, and Latino residents from participation in the policymaking process for the Bay Delta plan. And speaking of which, proceeding with the hearings in this project before the board has completed its update of the Bay Delta water quality standards is deeply problematic to my clients. These standards are undergoing significant revisions that will directly impact the Delta Conveyance project's compliance. Moving forward without these updated standards in place means that the board risks evaluating the project against outdated criteria, which could have dire consequences for the ecological health of the Delta, the sovereignty of Delta tribes, and the well-being of Delta communities. Although DWR might argue that they can incorporate the updated standards later, to us, that is still no justification for unduly expediting these proceedings right now. And finally, I'll wrap up. As Mr. Keeling correctly pointed out, we do need to recognize the lessons learned from past water projects. And while I know that the Delta Conveyance project is not the same as the Water Fix project, its more than $20 billion price tag makes it a massive undertaking. And as of right now, we do not have clear assurance that the project is economically sound and consistent with the allegedly soon to be updated Bay Delta standards. And in light of those facts, rushing into these hearings could lead to another expensive and time-consuming misstep. So for those reasons, we strongly urge the hearings office to defer all upcoming hearing and pre-hearing dates and deadlines until, at the very least, after the informal resolution period concludes on November 12th of this year, if not longer. I will now yield some time to Gary Mulcahy, Crystal Moreno, and Barbara Berrigan-Perea. I will first turn it over to Gary from Winnemem Wintu Tribe to discuss the burdens of the procedural overlap between the Delta Conveyance project and the site's reservoir proceedings.
Thank you.
Thank you, Tara. Well, the Winnemem Wintu Tribe is a tribe in Northern California. We're in Shasta, and Siskiyou counties. Many of the people on here know who we are, know our story, so I won't get into that. But we only have about 125 members, and out of those 125 members, there's 2 of us that are able to write documentation, write commentary for BIOPS, for programs, for processes, and that's it. And we don't get paid for that. We don't have a staff full of State Water Resources Control Board employees that can manage 3 or 4 or 5 different projects at a time. We don't have staff like DWR that can manage 2 or 3 or 4 different projects at a time. We are buried. Right now, we have the LTO, which is the long-term operations plan, BIOPS that are coming out, that are comments need to be on that. We have voluntary agreements that we've submitted comments on, and we'll have to attend any hearings on those. I am currently committed to testifying before the site's project authority based on their impact on tribal cultural resources and tribal beneficial uses. DWR, about 8 years ago, 9 years ago, did a confidential tribal cultural landscape based on the Winnemem Wintu tribe, which they confirmed, and that our tribal cultural landscape went all the way from Mount Shasta down to the Suisun Bay, because we have tribal cultural resources that are in the Sacramento River, including salmon and other cultural resources that are going to be impacted by sites and going to be impacted by the Delta Conveyance project. And we just don't have the means to address all of these all at once. Like I said, we don't get paid for it. We're very extremely spread thin. We have all of these projects and all of these things that we need to comment on. And I was part of the representation on the California water fix. And let me tell you something about the California water fix. Anne says that it's just a little minor tweak for their diversion or anything. That's a new water permit. That diversion has never been done up in the Sacramento River that high up. So in order to get that diversion, it's going to be an application for a new water permit, not an amendment to a current water right. And that was one of the big contentions in California water fix, and that's one of the reasons why it went away. And that is still going to be a contention if they continue to go down that path. I'm also part of the civil rights complaint filed against the State Water Resources Control Board for denying tribal people, disadvantaged communities, and people of color the right to be part of discussions for water policy, especially in the VA process. They excluded everything, and they're still considering those as part of the State Water Bay Delta Plan Water Quality Update. Sites project, Delta Conveyance project, all are going to have to rely on the water quality processes and water quality definitions and water flows that will come out of the Bay Delta Plan update. And to continue these hearings when that isn't complete yet, to continue these hearings when there's no resolution yet to our civil rights complaint against the State Water Resources Control Board and our petition for rulemaking against the State Water Resources Control Board is just way too premature. There are items that they are considering and need to define within the Bay Delta Water Plan update, and items that are still unresolved: tribal beneficial uses and where those fit in the water quality update, tribal water rights, and tribal water rights are becoming a very important part because Sites Reservoir and the DWR have not taken into consideration tribal water rights and whose water rights those are affected by their proposed conveyances and proposed capture of water off of the Sacramento River. They designate certain water as unallocated water. Well, how do they know it's unallocated water if they have not determined the tribal water rights? Those tribal water rights may not be unallocated. They may be reserved for tribal water rights, and they're not unallocated. These are things that need to be resolved before we go forward with this project, or even with the Sites project, which I'm a party to. And we sincerely and most respectfully ask for a postponement, like Tara said, at least past November 12th, so that we can have an opportunity to put our testimony together, put our case in chief together, write our comments, because of the numerous avalanche of projects that are hitting us all at once right now. I'll reiterate it again: long-term operations plan, Sites Reservoir, Sites project, DCP, voluntary agreements, State Water Resources Bay Delta Plan update, civil rights complaint, and petition for rulemaking. So if you want to give disadvantaged communities an opportunity to participate effectively in this process, and tribal nations effectively to be able to participate in this process, we sincerely and most respectfully ask that you postpone these proceedings to a later date to allow us the opportunities to prepare. That's what I have to say.
Thank you, Mr. Mulcahy.
Thank you, Gary. Crystal Moreno from Shingle Springs Band of Miwok Indians would now like to briefly discuss the procedural hardships associated with the current hearing schedule for tribes who are participating in the annual ceremony at this time.
Good morning. I will do my best to not repeat all of the things that Gary said because we share many of the same challenges. What I will say is, again, emphasize we are requesting a delay. As Gary stated, we are buried in multiple water agency, water governance processes and projects that, as proposed, would negatively impact tribal communities. Not only does the timing for this protest process overlap with Sites protest and testimony, which we are also a part of, it also overlaps with the Bay Delta Plan update. And that is another process that we are heavily involved in. In addition, we are needing to make comments that are due, or in this case, past due, such as on DWR's DEIR on the State Water Project operations. That coincides with the Bureau of Recs DIS comments on federal water operations. And all of these are projects that are potentially harmful to tribal communities. In addition to these, the most important is that Shingle Springs right now is heavily focused on the planning and preparation for our largest and most important ceremony of the year, our big time. That's 3 days and 3 nights of medicine. And that is something that we, and especially I and my boss, the vice chair of the tribe, are responsible for ensuring for the entire tribal community, not just for Shingle Springs, but for our neighboring tribes in the region. This is very important to many of us, not just Shingle Springs. These overlaps directly and disproportionately impact the tribe's ability to fully participate in these proceedings. We ask for a delay. Thank you.
Thank you, Ms. Moreno. And if I may ask a follow-up question, if you're willing and able to answer, with respect to, because I'm simply not aware, with respect to the annual ceremony, what is the timing? Are you able to, are you willing to articulate it? I'm not only for this process this year, but comes up every year. So I'd like to be more aware about the timing for that.
Sure. So it's ours is actually at the end of this month. But what many folks don't understand is that this time of year is ceremony time for many tribes throughout the state. So we don't just participate, in our big time and plan for our big time. Part of that good medicine is also going out to our other neighboring tribal communities and participating and spreading that good medicine within their communities as well. So that's just something for you all to be, aware of. Because as we know, it's been very challenging, right, for tribes to get to the table. Capacity is an issue, but we also have our priorities, which are not steeped in this system that we have to adjust to working within. We also have these ceremonies and these things that take priority no matter what else is going on.
Thank you, Ms. Moreno. I appreciate that clarification. That's helpful to be aware of that.
Thank you, Crystal. We have one more speaker. Barbara Berrigan-Faria from Restore the Delta would like to emphasize the importance of centering environmental justice considerations when setting the hearing schedule. Go ahead, Barbara.
Good morning again, Officer Kenzie. And I would like to also echo the comments made by Gary Mulcahy and Crystal Moreno. The Delta is a majority disadvantaged community, according to surveys done by the Department of Water Resources, the entire region. And EJ communities, even without overlapping processes, struggle to work in a timely manner with representation and legal counsel in order to be able to participate in processes around water. The Delta Conveyance Project, to move forward with it without an operations plan, even if it's going to be dropped at the end of August, is going to really be an impediment to analysis for environmental justice communities. And it will continue a pattern and practice of discrimination and exclusion, as is in our civil rights complaint, because we will not be able to adequately evaluate changes to water quality that impact the day-to-day lives of people who live here with toxic algae, impaired waterways, and other on-the-ground problems. Very often, in having been through a water fix, having been in front of the water board for years on the Bay Delta plan, time and time again, we find and have found in the CIR that our concerns are not addressed for this majority disadvantaged community region. And that when you read the narrative and you dig into the appendix, or you read the narrative and you look at outside sources, the facts don't match up with what is presented as the project. So we have to really do our due diligence to research to get at the bottom of what will the impacts be on our communities. And in the best of circumstances, for environmental justice communities to prepare and participate with its counsel, a case in chief, 3 to 4 months wouldn't cut it. But then when you put on top of it all of the processes that my colleagues have listed out for you, and when you consider the fact that the Bay Delta plan is going to impact this and change the water quality standards, we're not going to be able to prepare anything with accuracy for the hearing. So for that reason, we are asking for the delay as described by council. Thank you.
Thank you very much.
That's all we had.
Ms. Bear, I just have one follow-up question. Well, maybe two. Well, we'll keep it at one, which is you had asked for a delay until after at least, I understand this is a minimum, at least until after November 12th to close the completion of the 180-day negotiation period, as we casually call it. Although I want to emphasize, I hope these discussions will continue after those 180 days. What is it that you want to defer until after November 12th? Because of course, and I just want to make sure this is clear on the record, because the hearing isn't scheduled to start until after November 12th, of course. What is it that you're asking to defer? What would that look like?
Right. I mean, the hearing isn't scheduled until after November 12th, but I mean, we want to push everything back, even though the hearing isn't scheduled until January. You know, parties still have deadlines to file case in chief exhibits and other evidentiary portions of the hearing before then. You know, we have additional pre-hearing conferences and deadlines that have to do with submitting comments on the hearing issues. And so we want to push everything back. I think ideally we wouldn't even have another one of these meetings until after that point, since, as other parties have stated, you know, we are interested in participating in those informal resolution discussions. There is room for narrowing the issues of our protest. And so we're asking for sort of an across the board deceleration of the current schedule.
And thank you. So I think looking at the schedule, starting with the September 5th deadline for written comments on the hearing issues, that date would be moved to sometime after November 12th. And
that would be the most immediate concern.
As a minimum.
Yes.
Yeah. Okay.
Yes.
Thank you. Thank you, Ms. Bear, and thank you, Ms. Safdie, for being here to supervise as appropriate. Appreciate it. I think I would like to keep going. At some point, I will take a break for all of our health, a brief break. But for now, let's move forward. I have California Indian Environmental Alliance, Ms. Norris. Are you able?
Can you guys hear me?
Yes, I can hear you now.
Hi. I expressed similar concerns as my colleagues, in particular, in addition to what's already been brought up. So I won't repeat what they have said, but I will say that I'm really concerned that the operation plan is not being released in such a way that we can accurately review how this project is going to function. That is going to be key to understanding how it's going to affect water rights, how it's going to affect toxins that are in the system, how that's going to affect current TMDLs and water plan and the Delta plan. Also, I'm really concerned about the fact that communities and tribes in the source and receiving waters have not been contacted. I'm wondering if that contact is going to happen during the release of the operations plan, because that's when it's really key for them to be engaged in these conversations. I've spoke to many community members and tribes in the up project area, the source and receiving waters, basically in the Bay Delta area and through to the San Francisco Bay. All the way through, people are saying, wasn't that the water fix and isn't that over? Which makes me very, very sure that the outreach, I haven't seen outreach happen in those areas. And it's not, so I'm concerned about the not only the public trust, but then when we get into the fairness and the equity and the racial issues that were brought up earlier by my colleagues, that I just don't think I think this is being pressed forward in such a way that the community is unable to participate and to understand what's going to be done to them. That is all that I have at this time. Thank you so much.
Thank you, Ms. Norris. Continuing forward, I have CSPA. Mr. Schutz, do you have comments?
Sure, and I'll try to keep them not repetitive of what others have said. I share many of the concerns that both our friends from represented by Ms. Bear, as well as Mr. Keeling and Mr. Moore's letter, and Ms. Tabor's comments have many of the same concerns. I'd like to point out a few sort of more practical issues in the immediate terms, and doing so, remembering that during the California water fix, there was a lot, that process just procedurally, because new information was coming in during the process, it made it extremely cumbersome, and although I don't think we're going to have complete supplements of thousands of pages of EIRs in this hearing, the new information process and trying to work on the airplane while you're flying it was really a challenge. One of the big concerns I have, just in terms of practical issues, is that we're asked to present case in chief testimony in December. The protest resolution period ends somewhat before that, and we don't know. There may be certain issues, sort of broad topic areas, that we feel compelled to present evidence and testimony on, for instance, on water transfers or on the role of the Central Valley Project and its use of this proposed new facility. If we can narrow some of the issues there, that could significantly narrow the range and subject matter of testimony that we need to present. Personally, we have our first protest resolution meeting with representatives of DWR tomorrow. I don't fault them. We've been responsive and willing to accommodate a meeting for well over a month. I don't fault the folks at DWR for not having been able to do that. However, these things sort of drag on, and we've already a couple of months or more into the protest resolution period without having an initial discussion. I don't believe, and I don't think DWR believes, that CSPA is going to dismiss its protest, but it may narrow some issues. And we have laid out about 20 specific topic areas, and we can get those down to 15. That would certainly help us in preparing testimony. There's the whole issue of antecedent kind of processes that a number of folks have raised, and I won't go into all of those or what I think is the right answer on all of them. I would point out that it's been DWR's position in this process that the update of the Bay Delta Plan is going to address the statutorily required issue of appropriate delta flow criteria, and not knowing whether we're going to have voluntary agreements, whether we're going to have some regulatory approach, as in the draft staff report for the update of the Bay Delta Plan that was proposed in September, I believe it was, or August of 2023, as the sort of requirements that we're going to be seeing. That substantively stands out to me as one process that, if we don't have greater clarity, at least on where we're going on that, makes it very hard to understand what the operations are going to be, operations plan or no. The operations plan, as I understand it, has to do with the proposed constraints on the operation of the tunnel itself, the intakes, the diversion criteria, those kinds of things. Leaving aside my general concerns with that definition of an operations plan, there are a lot of other things that probably will not be included in that. Well, I do think it's important and helpful to have everything in one place. On the other hand, it doesn't really answer a lot of the questions that we're going to have. So, assuming that it's the will of the water board and others perhaps asking the water board to do things, that we're not going to wait for the completion of the update of the Bay Delta plan or other things. It does seem to me that having time to review what the subject matter of our testimony is going to be after the protest resolution period, and having an appropriate amount of time to prepare that, and hopefully not having to once again do all that over the holidays, sometime in late winter or early spring to actually submit testimony for the cases in chief would seem to be minimal to me. And that's leaving aside the issues that many have raised about where this ought to be in terms of antecedent processes. So I think that's kind of what I'll limit my substantive comments to. I will say that process-wise, CSBA certainly shares the concerns and the difficulties of being a very small organization, not having some of the folks we had in Water Fix available either through age or death to engage in this process, and having a multitude of obligations such as those Mr. Mulcahy laid out, excuse me, makes it extremely challenging. And frankly, it's our effort whenever we do this to do as good a job as we can, to be thorough and technically competent, and rushing does not help us to live up to the standards that we hold and that we think are appropriate for this process. So that's my thought. Thanks.
Thank you, Mr. Schutz. As always, your comments are very thoughtful. Thank you. I think, I know we're moving forward quickly, but I think I would like to call about, let's give ourselves a 7-minute break for whatever you may need to do the next 7 minutes, and let's return at 10:40 on my clock. I have 10:33, so 10:40. And if you just turn off your cameras and be sure to mute, so if you have side conversations, we can't hear it. And I will see you in 7 minutes. Thank you.
I have a hard stop at 11, Nicole.
And just to let everyone know, we'll be going back on the record here shortly in about a minute. All right, I see that you're here, Mr. Moore. Let's go back on the record. And I believe where we left off is with you. Do you have comments on the schedule as it is currently laid out?
I do. I appreciate you reading our pretty detailed pre-hearing conference statement, and will do my best not to simply repeat the very eloquent explanations already provided this morning about the prematurity of the schedule. In terms of the legal dangers of doing so, I want to particularly note my strong agreement with the comments of Ms. Baer, Ms. Tabor, and Mr. Keeling. You have described the schedule in the hearing notice as fairly aggressive. It is more than that. It is outrageously aggressive under the circumstances presented, and on a collision course with what you have, I think, aptly described as the central point of the proceedings, which is to provide a thorough and robust record to reach the best decision possible. This is not simply aspirational, but a matter of legal obligation, because without a course correction, there will be no way for the board to honor its legal duties to fairly address matters such as protection of the public trust and determination of whether the application serves the project interests and protects the environment and fisheries, and even whether the Bureau, whether the board has the jurisdiction to act on the change petition in light of the limitations on water rights that you've already heard about. Rather than making things better in their presentation today, regrettably, DWR's representatives appear to have made it even worse. I suppose there's proverbial good news and bad news. The good news may be that, according to them, we will finally and belatedly see some semblance of an operation plan by the end of the month. That is, however, completely undercut by their recognition that apparently it is, by their presentation, merely going to repackage information, the already very inadequate and sketchy information that is in existing sources such as the EIR and the ITP application. As you've heard about this morning, the matter of operations is entirely foundational. And I should note that that is not only the case for the merits proceedings when they are ripe for determination, which they are clearly not yet, but also for the integrity of the 100-day period for protest resolution that is required as a matter of law. We must do better. The environment and the law demand it. I want to comment on and just highlight the prematurity, noting several of the things that are mentioned in our pre-hearing conference statement and have also come up this morning. The first is the direct conflict and substantial conflict with the already scheduled sites proceedings, where I should note the procedure was significantly different than was here. The pre-hearing conference proceedings, for example, didn't begin, as I understand it, until after the end of the 180-day protest period, more in line with how procedures should be. I should note that while there are clear conflicts that have been mentioned with the proceedings already scheduled through October 2024, presenting an obvious problem with, for example, the September 5th current deadline for the demanding task of providing written comments on hearing issues that have not even proceeded through the protest resolution stage yet. A further problem with sites is that the rebuttal and surrebuttal presentations have not even been scheduled, presenting a substantial likelihood that that those very demanding proceedings, on which Ms. Baer has correctly noted, there is a major factual overlap, a set of interwoven factual and legal issues. Those proceedings are quite likely to require further attention in the months to follow, November through the beginning of next year, precisely when the current hearing schedule here has very substantial deadlines scheduled, including the early December deadline for the case in chief. CWIN is also one of the parties involved in the site's proceeding. As has been noted, both proceedings involve environmental justice communities, non-governmental organizations, and also public agencies with a long history of participation in proceedings relating to the protection of the Delta. All these voices need to be heard loudly and clearly in both proceedings without any conflict whatsoever, and that can only be done if the proceedings are rescheduled. The second thing I want to note in terms of areas of conflict is that the current schedule is, I think, at odds with the functionality and central purposes of Water Code Section 1703.4, the provision that calls for good faith efforts to resolve protests within the 180-day period, a task that CWIN is attempting to take seriously, and as you've heard from others, they are as well, to make use of this proceeding, which the legislature has intended to be available to all. It is outrageously little time and grossly insufficient time to have a December 4th deadline for submission of exhibits for the case in chief. In a proceeding like this that has dozens of parties with extraordinarily complicated issues that will affect not only the future of the Delta, but the future of California's environment and economy for decades to come. There is no excuse and justification for proceeding this quickly. And as Mr. Keeling, for example, alluded to, DWR is in pretty much the worst possible position here to insist on even a fairly aggressive schedule. I believe you mentioned some charge in the process to proceed as immediately as possible. The charge should be to make sure that all voices are fully and fairly heard and that the law is followed. Here, DWR has just recently lost in its validation action, which resulted in the invalidation of its Delta program bond resolution. It has lost on a motion for preliminary injunction that now prevents it from going forward with geotechnical activities as an integral component of the project because it has not complied with the certification requirements of the Delta Reform Act. And in those litigation proceedings, it is clear from DWR's own briefing and evidence presented that by its own recognition, the project is at a very early design stage. I think the figure used by their declarants was 2%. And that even under the best scenario that DWR's own experts and declarants can present, this project would not be, whatever its merits, which we cannot reach yet here, it would not be online by DWR's recognition until 2045. There is no justification for such expedited proceedings here. I also want to comment just a little bit further on the subject that has come up regarding the failure thus far in the scheduling to ensure that there will be timely resolution of closely related water rights protests before the board proceeds with the merits of the change petition. Without that, there, as Seawin has noted in its protests and others have as well, there is even a question about whether the board has jurisdiction to proceed with a change in water rights permits whose operative deadlines have long since passed. It came up today that the 2009 application of the department for an extension is in a certain sense moot because the deadline request, among other things, the deadline requested there, I think, would have only extended until 2015. But the 2010 protests that the board for the last 14 years did not act on do not simply protest against that immediate application. They protest any further extension on numerous grounds that remain central problems of law, such as GWR's long failure to exercise required due diligence and failure to comply with multiple requirements of law, including protection of the public trust and the public interest. That record and the board's inaction in response to those protests is also the subject of litigation currently pending in Fresno County Superior Court, in which Seawin and Central Delta Water Agency and others are involved, as you have heard this morning. The concern that these proceedings will, under the current schedule, prejudicially proceed to the merits without addressing the underlying water rights problems is not simply a matter of idle concern. In fact, you have heard from DWR this morning that its apparent plan is not even to deal with that in this proceeding, but to consign it with another one. And it is signaled just that in a related document. It's May 2024 draft environmental impact report on long-term operations of the State Water Project, where, as we've noted on our pre-hearing statement, DWR anticipates relying on this still very incomplete document that has just been the subject of numerous detailed public comments. This document that the public does not have yet is the one that DWR apparently is going to rely on to inform some future discretionary approval process that it has not gotten around to doing yet, even though the construction deadline in term 6 that you've heard about this morning actually expired in 2000, 24 years ago. the changes that DWR wants cannot in any sense be characterized as minor revisions. DWR this morning did not even mention the other expired deadline from 2009 relating to beneficial use. All these matters need to be addressed, not head-on prior to the board proceeding to the merits of the change petition here, and no more leeway can be allowed to DWR to kick the proverbial can down the road yet again. Next, as other protestants have eloquently noted, the information available is currently vastly insufficient to proceed to the hearing on the merits. You've heard about a lot of the reasons why already. We certainly agree that the missing information on operations is foundational, and also that the board will not be able to reach its required determinations here, including those relating to the public trust and the public interest in protection of fisheries, for example, before the information is available from the parallel Bay Delta water quality update on such matters as the anticipated selection of flow requirements and the identification of a preferred alternative. In sum, there are multiple reasons why this is, as I believe Mr. Keeling noted, not even close to being ready for prime time. A course correction is needed in order for the board to meet its basic responsibilities in this proceeding.
Thank you, Mr. Moore. I appreciate that. Continuing down my list, I have Friends of the River. Do I have Mr. Bob Kerr? There you are.
Yeah, just getting on camera and off mute. Thank you, Ms. Kenzie. Before I start, I should also note that in addition to Ms. Dorman, Ms. Keiko Mertz of Friends of the River has also joined the meeting. So Friends of the River joins with numerous parties that you've heard in requesting that decisions about scheduling, about preparation for the proceedings be deferred for a variety of reasons. I won't repeat all that you've heard, but I'll just maybe sum up what I think are some of the most important. The first is that like other parties, we agree that it's appropriate to wait until the conclusion of the protest period in order to assess what is actually going to be in the scope of the meeting. While I do not anticipate that Friends of the River is going to dismiss its protest, like other parties, we are interested in having good faith discussions with DWR and potentially would hope to be able to narrow the scope of the hearing, so of the proceeding. So that's just one particular concern. The second is obviously the overlap with a number of other proceedings, and as noted, the sites proceeding is a large project. It concerns a large project with complex implications for many of the parties. It's not only going to be burdensome and resource intensive to engage in that, but the schedule for completing that proceeding is unclear and potentially will directly overlap with this proceeding. We've also heard a number of parties very appropriately refer to the nexus with the Bay Delta Water Quality Control Plan proceeding. And that's a concern for a variety of reasons. As a number of people have mentioned, the decisions that the board makes in regard to the update of the Bay Delta Water Quality Control Plan have huge, highly significant implications for the design of this project, for the viability of this project. The impact just cannot be overstated. Plus, one thing that people have not really mentioned is that the board hopefully is proceeding with completion of that update in the near future. It's quite possible that we understand that documents for the water quality control plan update will be issued in the near future, in which case, in addition to working on sites, there's a need to review the documents issued by the staff, and then subsequent proceedings to consider amendments to the water quality control plan. So there's a direct potential for direct overlap, as well as the very significant implications just of the update, which could make this project look very different, or indeed make it moot. And then I think the final set of concerns surrounds the amount of information that we have. It's kind of a little interesting and baffling to me to hear the discussion about the operations plan. If the operations plan doesn't contain new information, then I think the board, as well as all the protestants here, are going to have to very seriously consider whether actually the proceeding can proceed absent important information that's necessary to make any determinations regarding the petition and the permit. And if it does contain new information, then that actually needs to be factored in to the schedule and process for preparing for the proceeding. And and with all due respect to DWR, I think we have to wait and see what comes out and determine just how significant it will be to review it and to analyze it and prepare comments on it relevant to our involvement in the proceeding. There are other issues that, I certainly want to support the concerns raised by the tribal nations concerning both tribal water rights and their resource capacity. That's, I think, something that should be of concern to all of us, given the past history of how tribes have been involved or not been involved in these proceedings. So finally, I'll leave you with this thought. There's a law. I've heard it referred to as Conway's Law, that is, there is never enough time to do it right, but there is always enough time to do it over. And, my fear is that the board is about to violate Conway's Law by proceeding so precipitously with the schedule for this proceeding. So I'll leave it at that. Thank you.
Thank you. I'll continue down the list, and it looks like I think I had doubled up here. So Mr. Wright, I'll turn to you on behalf of all of those parties who you are representing today.
Thank you, and of course, good morning again. And I've got a couple of very quick things to bring up at the end of my remarks. But in terms of why this action is dreadfully premature, I'm just going to talk about one thing. And it was first brought up this morning by Ms. Baer on behalf of some tribes and Delta communities, and has since been addressed by others. I mean, you can't make this stuff up. Under the current schedule, this hearing will start in January. On the other hand, the Water Board published an overview of what it's doing in the plan update on May 30th. And in that overview, they said by the second quarter of 2025, the board can consider adoption of the final update of the Bay Delta plan. Now, it could well be that issue number one will be, is this Delta Conveyance Tunnel project consistent with, or on the other hand, in conflict with the final approved Bay Delta plan? And I have to tell you, DWR is very concerned about it, because they did a late comment letter all comments were due on the September 28th draft Bay Delta Plan Staff Update Substitute Environmental Document. And DWR's director signed a late letter on January 22nd commenting on that staff report and said, the staff report raises significant concerns regarding anticipated impacts to SWP agriculture and municipal and industrial M&I supplies, and additional impacts to power generation, agriculture, and M&I supplies could occur depending on the details and mechanism of POI, meaning program of implementation. So under the recommended plan amendments, there are very specific calls for increasing delta outflows to, among other things, protect the endangered and threatened fish species. And at the same time, pointing out that exports will be reduced by significant impacts, more so because of the Delta Conveyance project, but also additional reductions, I should say increases in exports for the Delta Conveyance project and the sites project. So it's kind of like they're running the wrong way here with the football. In terms of this Delta Conveyance project, arguably is running the wrong way against the current recommendations for the Bay Delta Plan update. So it just defies comprehension of why would we not wait until the Water Board adopts the plan, which of course many of us on this call today hope will do as much or even better than what the recommendation calls for, or on the other hand may go down the road of the voluntary agreements, which the EPA said in their January 19th comment letter on the staff update, no, that wouldn't do the job. But it's kind of like students being asked to take a test, and whereas the teacher hasn't even decided on what the standards are going to be for passing the test. It just really looks rather totally premature, senseless, and you have to wonder, why would the board be doing this, starting the hearing on the Bay Delta Tunnel, on the Delta Conveyance Tunnel project, instead of just waiting until we have the final plan. So our groups specifically call for not having any requirements to identify witnesses, write briefs, or do anything substantively until we have the approved Bay Delta plan. And I should say, it should certainly be possible for them to have it by the second quarter next year, as they currently projected in May, because they issued the draft in September 28th last year. The comment period closed on January 19th of this year. So it seemed like they have time to get that thing done and the final plan approved in the second quarter. So we all know what we're talking about, because I expect for many of us, the very first thing we would be putting into evidence would be the final approved Bay Delta plan. And in terms of then argument and opinions can be offered as to whether or not the project would even be consistent with what the board ultimately adopts. That's just huge. The only other a couple things I would say is we join and agree with what's been said earlier by Kelly Tabor, Tom Keeling, Tara Bear, and other speakers on behalf of the tribes and Delta communities, and Roger Moore. And like many of the other groups have told you, a number of our groups that I'm representing are also involved in the sites proceeding, and this is a terrible conflict in terms of time. So again, you've asked other people, what's your specific, what are you requesting? We're requesting that nothing be required in terms of designating witnesses, briefs, issues, until we have the approved Bay Delta plan, which is expected to happen by the Water Board in the second quarter of 2025. Thank you.
Thank you, Mr. Wright. Let's see, Mr. Spain, I have you next on my list here.
Thank you, Officer Kinsey. Can you hear me okay?
Yes, I can. Thank you.
All right. Well, I will be brief. I want to underscore that we support various of the comments made by Mr. Keeling, Tara Bears, Roger Moore, Gary Bobker, and just recently, Bob Wright. It's premature. This is a partly baked idea, basically, and it needs a bit more cooking for sure before we have things like water quality standards by which we can judge. There are other processes that are in underway that will be finished sometime soon. One of them is a new salmon biological opinion that will govern the CVP project. That is due out for final approval sometime in December. We, of course, I think all see the logic or illogic of moving things before there's the period for the protest resolution, the informal resolution process is closed. So that at least should be cause for postponement to November. November 12th is the deadline for that. There are all these processes in the way, all these standards that are not yet defined, by which we would determine the merits of the project. So at least we need to solve some of these problems first. We need to put the pie back in the oven a bit and bake it more before we have these standards. And in terms of conflicts of scheduling, we have the same problem. We did sign on to the Buena Vista Rancheria tribe comments. We have the same problem. We represent coastal fishing communities. Fishing communities with no salmon season for the second year in a row. We are also a disadvantaged community. We are also stretched very, very thin in all of these processes. And they will all affect the future of salmon and salmon fishing in this state. So we have to be engaged in all these processes. So we have the same concerns with lack of standards. We have the same concerns with booking basically these various issues, simultaneously layering them on each other, and at a time when all of us have very minimum resources. So with that, I will say we do support the effort and comments of the other parties with respect to some delays. We need some reasonable scheduling to take into account these other processes that are near completion. It won't be too terribly long, and given the difficulty of, as I think Chris Schutz pointed, working on the airplane while you're flying it simultaneously, it can't be under repair at the same time it's in the air. We really need some sequencing here to make sure that we move in a more orderly way, and that in the long run will save time for everybody. Thank you.
Thank you, Mr. Spain. Golden State Salmon Association, Mr. Artis.
Hello, thanks, Officer Kinsey. Yeah, Managing Attorney Eric Boucher of San Francisco Baykeeper will be speaking to many of our issues and concerns for Golden State Salmon and our group's specific request to postpone the proceedings as described in our pre-hearing conference statement that was submitted on August 7th, which also echo what many have raised this morning from tribes, Glenn Spain just now, Chris Schutz, Restore the Delta, and others. And so I'll just keep it brief with that. And, really we're also wanting to know what exactly the Water Board's preferred alternative for updating the Bay Delta water quality standards will be as well. But I will defer to Eric from Baykeeper to go over all the details. Thank you.
Thank you, Mr. Artis. And with that, I will turn to you, Mr. Boucher. Please go ahead.
Thank you, Hearing Officer Kinsey. I'll start and just echo and endorse the comments that others have raised this morning, especially Ms. Baer, Mr. Mulcahy, Ms. Marino, and Ms. Bargan-Perea. One point on the Bay Delta Plan, and then two thoughts on why the current schedule is kind of needlessly fast and impractical. We heard from Ms. Carroll for DWR this morning that this project is about excess water, capturing excess water. This is a similar issue that's going to come up in great detail in the site's reservoir proceedings. And really, this is what the Bay Delta Plan is designed to address part of. Right? The State Board and other expert state and federal agencies have repeatedly found that the Bay Delta ecosystem is in crisis because of current diversions and the corresponding reduced delta inflow and outflow. The status quo is unsustainable, but the regulatory minimums that currently exist are only about a third of the status quo delta outflows. The existing minimums, as the State Board has explained, are inadequate to protect public trust resources. So when we're thinking about excess water, the Bay Delta Plan is designed to update those existing inadequate minimums in order to reasonably protect beneficial uses related to fish, wildlife, endangered species, tribal beneficial uses, and commercial, recreational, and subsistence fisheries. And fundamentally, trying to figure out what is excess water for this proceeding before we know what the regulatory requirements are puts the cart before the horse. Two other thoughts on the practicality of this. One, as several people have recognized, the overlap in the site's proceeding is significant and untenable. As I count, there are 15 days of evidentiary hearings scheduled between now and October 10th for case-in-chief evidence in the site's matter. Based on the witness disclosures and the expert testimony that has been submitted in that case, and as we prepare for those hearings, it looks like we're going to need more than those 15 days to complete case-in-chief testimony and cross-examination. And add to that the as yet scheduled rebuttal and surrebuttal phases that are going to arise in that process, because the hearing began before all of the information was available to the board and the parties, means that there's likely to be evidence through the end of the year and into January, and certainly past when case-in-chief evidence is currently scheduled to be due in this matter. And then ultimately, this is a project that, according to the most optimistic projections from the department, is not going to be operational for 20 years. Rushing to complete this water rights process will not speed up that timeline. And more importantly, doing this process through a normal procedure that respects the integrity of the resolution process and produces the kind of robust and appropriate record that allows the state board to make an informed decision based on the best available science and evidence will not delay that 20-year timeline. So we reiterate our request to wait until the site's process is done, wait until there's an updated Bay Delta plan, and then schedule a pre-hearing conference to address the host of complex procedural and substantive issues that have already been raised today before we get to the expert evidence about the case-in-chief and the case-in-chief testimony. Unless you have questions, that's all I have.
Thank you. I appreciate your comments. Thank you. Next, I have, let's see, I believe Ms. Desjardins has joined us on the Zoom, so I have you on my list next. Ms. Desjardins, if you have comments, we're discussing the schedule as it's laid out in the July 31st hearing notice. So if you have comments on that schedule, this is your time. Please go ahead and welcome.
Thank you. I actually have a concern. My protest is regarding a lack of information provided for the hearing parties and the hearing officers in consideration of this. And I did not receive a good faith response from the Department of Water Resources. And I would like there to be a procedure to go into discovery. But I also think that the failure of the Department of Water Resources to attempt to provide, I wanted them to provide more information about climate change and also about there was some corruption in the Delta Conveyance Design and Construction Authority Stakeholder Engagement Committee, which regarding the placement of the intakes at Hood particularly, but and so both of those are very key to issues in this protest, and particularly regarding environmental justice issues. The town of Hood is a poor town, and there's a lot of Latinos in there and Latino community, and it's just absolutely inequitable to proceed without trying to at least get the Department of Water Resources to provide that information in a timely way. So I would ask that the hearing officer request that the Department of Water Resources make a good faith effort to provide the information. And if they don't, provide a reasonable time for discovery, because parties were doing discovery during the hearing, the water fix hearing, and they didn't get information that they needed in a timely way. And it was a major issue in the hearing. So thank you.
Thank you, Ms. Desjardins. I appreciate that. Next, I have Aqua Alliance.
Thank you, Ms. McKenzie. Can you hear me all right?
Yes, I can. Thank you.
Okay. Aqua Alliance concurs with numerous of the previous speakers. We believe if foundational documents are not produced and numerous issues are not resolved, that this schedule will seriously impact the people, family farmers, and communities of Sacramento Valley and Foothills unnecessarily. It must be changed, and we look forward to some resolution of these issues very soon. Thank you.
Thank you. San Joaquin Audubon, Mr. Freeze, I believe.
Yes, I'm here. Yeah.
Yes.
Yeah, I agree with most of the comments that have been made. I'd just like to add a couple additional comments. The Independent Science Board of the Delta Stewardship Council has described the Delta Conveyance project as a massive experiment that is not adequately supported by scientific evidence. Assuming that we can negotiate some of these scientific points related to this, some of the issues may be negotiated, and it will require a rewrite or major supplementation of the EIR, I believe. Is it reasonable to assume this is going to take place before the hearings occur? And is it reasonable to have the hearings before we know what's really in the EIR? In addition, I think a point that's important is it's not at all probable or sure that the Corps of Engineers is going to approve DWR's approval petition for this project. Scheduling hearings before we know the decision of the Corps is a waste of time in my mind. And I think it's a waste of public resources and the time of hundreds of individuals who were protesting this process. So I think till we know at least what the Corps of Engineers decides, it's moot to schedule any kinds of hearings. That's all I have to comment on.
Thank you. And before I turn back to DWR, is there anyone else on the line who I missed and who did not have an opportunity to comment on the schedule?
Hearing Officer Kinsey, this is Brian Polson from El Dorado Irrigation District.
Please. Yes, you were not here earlier, but you're here now, so welcome. Thank you.
Apologies for my late entry.
Okay.
Thanks for obliging me. Yeah, I just want to point out this is not something that is new. A number of folks have commented on this, but I just wanted to specifically point out that the that the first, the deadline to submit written comments on the hearing issues is September 5th. And if an operations plan isn't released until the end of August, there is really no meaningful time to be able to review that and then provide a reasonable comment on some of the hearing issues. I'll just point out, hearing issue number 2, would approval of the petitions result in an injury to water users? Well, I imagine the operations plan is going to be informative of that issue. And so if we're able, we really should be provided a reasonable opportunity to analyze that operations plan to then be able to submit written comments. So at the very least, I would think that a stay in the September 5th deadline for submitting written comments would be in order. And I just submit that for your consideration. Thank you.
Thank you. I appreciate that. Is there anyone else on the line who did not have an opportunity to comment? Then I will look back to Ms. Carroll or anyone else from DWR. Are there some closing comments that you would like to make?
Yes, thank you very much. We just wanted to clarify that our understanding is we don't need to put evidence on before the hearing begins or before the deadline for case in chief. So our operations plan is really a good faith effort to provide a compilation of the operations and describing the implementation of the project. Like we've previously stated, it's already existing information available to all of the protestants and the public in general. Also, we think it's beneficial to have the statements in before the end of the protest period. It's really going to clarify and help us narrow the scope of the discussions with the protestants. We're hoping to use those in our meetings with them, and we are going to be continuing to reach out and scheduling meetings and are open to that and want to make that offer to everyone on the call in the hearing today. We also appreciate that we believe the board is already being mindful of the various schedules with the various hearings before the board. And we appreciate how you have set out the timeframes and believe that there isn't a need for delay at this time. And then finally, I just want to clarify on the time extension piece that I brought up, is the minor amendment that we're going to be submitting before the end of the month is really just for construction. We recognize that by law, our water right is limited to the maximum historical use until the State Water Project water right time extension is processed. But we think there's plenty of time to proceed before we've completed construction on the Delta Conveyance project, and that separate petition will resolve the issue with regard to operations. So those are our closing comments if you have any questions.
Thank you, Ms. Carroll. Just one follow-up on the narrow issue raised by Ms. Desjardins. I think, as you know, discovery is a burdensome process if we get into that. So I would appreciate if you are willing and able to please do have a conversation with Ms. Desjardins. And if there are documents that you can produce subject to a public, if it's a Public Records Act request, something like that, so we can avoid a formal discovery process, I would, of course, appreciate that. So I just wanted to add that.
Absolutely. Absolutely. And I'm hoping we have the right phone number for her because we did leave her a voicemail on July 5th. Asking for her to reach out and to meet with us. So please correct that if we have the wrong one from the petition.
Thank you. With that, is there anything, well, let me lay out what I'm thinking the next steps are. September 5th is coming up real fast. So you need to know from me whether that is going to stay on the books. I think it's likely that is, at the minimum, that will change at least somewhat. So I'm going to put that out there. What I will commit to doing is getting back to you. It won't be this week, but by the end of next week, so before next Friday, the 23rd, that I will get back to all of you, the service list and all of you on that September 5th date. It may just be somewhat informal by email, if that's the fastest way, but I know you need to know whether that date is going to move slightly, so we'll get you some room, but I will confirm what that date, give you more information about it at that time. All of the other comments, of course, I want to thank you to all of you for taking the time to be here. I know this was a long conversation. This was quite helpful, and there's a lot of information for thought. We are, of course, going to sleep on all of this and consider it. Out of this proceeding, there will be some kind of formal action from me, a procedural ruling, whether it's in the form of a ruling or an amended hearing notice. That may take some time to put together, so it may not be before the end of next week. That's why I wanted to let you know there'll at least be some kind of email to confirm this September 5th. How do I want to say this? Provide more clarity about how long the September 5th date will be postponed. Okay, let's put it that way. And that's the September 5th date is the deadline for written comments on the hearing issues. With that, I think this procedural ruling will provide more clarity, but are there other issues that you want to raise or other than the schedule and everything we've already talked about, which took some time to go through, are there other issues that we need to address today that you think would be important to put on the table today? And I see your hand is up, Mr. Schutz. Please go ahead.
Yes, two questions. One is, if we filed a notice of intent to appear at this pre-hearing conference, are we going to have to file another notice of intent to appear in the hearing itself?
Please do, if you don't mind. I think some folks we had provided a kind of an amended notice of intent to appear just for this pre-hearing conference that some used, and then some used the standard one. So you may have, Mr. Schutz, use the standard one. So I know you intend to appear, but if you don't mind filing maybe it can even be the same one, refiling it. So we'll put it in the right folder and then I just won't miss it.
We'll change the date. Thank you.
Thank you.
The other question is, how do we go about adding or taking off folks from the service list?
If you would just please email the DCP email address and just ask, and you don't need to CC the entire service list for this kind of a request, and just ask for those updates to the service list. That would be the best way. Thank you.
Thank you.
And we do have a service list that we're maintaining on the DCP FTP site. So if you, for any of you, if you take a look at that and there are changes that need to be made or changes that you asked for that then aren't reflected in pretty short order, please do follow up. It's a list that we continue to modify and update. Are there any other questions or issues to raise before we close out our morning? Mr. O'Brien.
Ms. Kinsey, one of the issues identified in the notice was whether a site visit would be useful. And I just wanted to make the comment, North Delta Water Agency is ground zero for this project. And we will be raising a number of issues about local impacts on, for example, on diversions, agricultural diversions that use siphons in the Delta, on water quality in the North Delta. I realize it can be a little bit inefficient to have site visits, and most judges don't like to do them. But I think in this proceeding, since you're going to be hearing a lot of evidence about some of these physical factors, taking the time to go out there and actually see on the ground what we're talking about would be very helpful.
Thank you, Mr. O'Brien. I appreciate that point taken. And for some background, we will talk about this issue again in a later pre-hearing conference, but to provide some background on what I'm bringing to the table is I frankly have never done any kind of a Delta tour. I'm blank on that as well. So that is, I think, an argument even more in favor of a site visit in this instance. So I will put that forward for all of you to think about. Are there any other comments, procedural issues for us to address at this time? With that, then I will say I want to thank all of you very much for your time this morning. This was quite helpful. I know it takes some time to go through this. I really appreciate all of your professionalism. And your representation today. It is, of course, we will do a better job with this proceeding with all of you participating and helping to make these informed decisions. So I appreciate your time and effort today. And you'll be hearing from the AHO soon. And with that, we are adjourned. I hope the rest of your day is lovely. Thank you.
Yeah.
Thank you.
Thank you.
Thank you, Officer Kinsey.
Thank you.